Welcome to Rapid Fire Wednesday, Q&A for corporate immigration professionals. I'm Kimberley Robidoux, partner in our San Diego office, and I'm joined today, as always, with the co-managing partner of our Boston office, Miki Matrician. How are you today, Miki?
I'm well. Hi, Kim. How are you?
Good, good. So we have an interesting topic today. We're going to discuss the topic that many people are asking us about these days, and that is what to know about entering the U.S. and going through the CBP inspection process. So everyone is screened by Customs and Border Protection, which we refer to as CBP, and they're screened at airports, land borders. Also, if you're going on a cruise, you'll be inspected if you're coming back into the US. So, in particular, we are fielding a lot of questions about what are the rights of non immigrant visa holders at these CBP inspections. In general, non immigrant visa holders have less protections compared with lawful permanent residents, green card holders, as well as with US citizens. So we recommend that global mobility and HR professionals make available for their foreign national employees some guidance about returning to the US following international travel. So being prepared and expecting the unexpected is really important preparation prior to traveling internationally. So, Mickey, when non citizens are inspected by CBP, there is a primary inspection at the counters. So, what general tips do you have for people that are entering the US with a non immigrant visa?
Sure. In general, foreign nationals should have passports valid for at least 6 months, as well as a valid visa stamp. They should also have documentation that underlies their visa. So, for example, for H-1B holders, that would be the Form I-797 approval notice. For other visa holders, they would have a 797 approval notice if they were approved by USCIS. Some other visa statuses, like L1 that was approved by the consulate abroad based on a blanket application, would have a Form I-129S that is endorsed by the consulate. And then for Canadian citizens that applied for L1 status at the port of entry, they would initially have an admission stamp, and then a 797 approval notice would be issued by USCIS later. For F1 workers on optional practical training, they would need their employment authorization document and Form I-20 that's endorsed within the last 6 months by their school. And they also need an employment verification letter. So, in most cases, it's a good idea to have printed 3 most recent pay statements to show that they're currently employed with their sponsoring employer. And then, aside from having those documents, it's important for foreign nationals on employer sponsored visas to be able to explain what they do in a way that's consistent with their approved petition. So, before they depart the US, foreign nationals should study the job duties set forth in the petition to make sure that what they're doing is aligned with how it's described in the petition. So if it's now different or if their job titles or job locations are outdated, they need to be alerting their human resources or global mobility and immigration council right away. And then in terms of answering customs and border protection officers' questions, it's really critical that people be completely truthful. Misrepresenting or lying can have serious adverse consequences. And then it's also worth noting that they don't need to over explain. So, in general, I tell people simply answer the question that's being asked by the officer. The officer doesn't want you to go into a long winded soliloquy about something, they want a simple answer on.
Yeah, so that's, some good tips, Mickey. We also have some people who might be sent to a separate area for what's called secondary inspection. And those individuals are routinely sent there because they are using their advanced parole to enter, right? So that's if someone is entering on advanced parole, you can know automatically you're going to be sent to secondary inspection. So others who might be sent to secondary are because CBP has additional screening that they would like to do with that specific foreign national. So, can you talk to us about what people should know if they are selected for secondary inspection by CBP?
Yeah, often we're hearing now about people having their devices searched by CBP. And with regard to that, it's important to know that you don't necessarily have a right of privacy when it comes to your electronic devices when you're coming into the US. CBP can search your device and may even access your email and your social media accounts. If you refuse to give up your device for a search, you may be denied admission to the US unless you are a US citizen. And we've discussed this in a previous Rapid Fire Wednesday episode for people who are interested to see it. People also ask us if there's a right to an attorney at CBP inspections, and generally the answer is no. It doesn't hurt to ask, but they may not permit you to have representation there. If it starts to get difficult and it looks like CBP may deny you entry into the US for some reason, one thing to think about is ask if you can withdraw your application for admission. That's often preferable to having a denial or expedited removal, which would mean you could be barred from coming back to the US for 5 years. And I would say too that if CBP asks a foreign national to sign something, it's important that they ask for an explanation of what they're signing. It's important not to sign any papers if you don't agree with what the form says or if you don't understand. And if you do sign the forms, you should request a copy for your record to share with HR, Global Mobility, and Immigration Council.
Yeah, absolutely agree. Specifically, getting a copy of anything that's signed. So, if CBP tries to get a foreign national to admit to things that they didn't do or to sign forms, it's really important to ask questions. And it's also important to know that someone can refuse to sign a form, especially if they don't understand what is in that form. If someone needs a translator, it's okay to ask for one. And also, I agree with you, Mickey, that it's important to be honest and truthful and not to be combative or belligerent, right? That will just make the situation only worse. So it's okay for a foreign national to say, I don't know. I don't know the answer to that question. And it's okay to say, I don't understand. It's better to say, I don't know or I don't understand than to try to answer and answer something incorrectly or in a way that you didn't, or the individual didn't mean to do so. However, if the person doesn't know the answer, it's okay to say, I don't know. And if the person does know the response to the question that's being asked, definitely respond with that answer, make it clear and make it concise, right? Instead of going on and on with a elongated response to the question. So, Mickey, do you have any recommendations for what to do afterwards once the individual is, out of secondary inspections?
Yeah, I would recommend that the foreign nationals write down the questions that are asked and what answers they provided. So, also noting the officer's name down and all of the other details, and then providing that information to Immigration Council to figure out if there are any next steps that should be taken.
Yeah, great information. So I think that's a wrap for today's session. Stay tuned for future episodes on updates to the immigration landscape here in the US. And if you don't already, please follow us on our LinkedIn page for WR Immigration, as well as our individual profiles. And we also transcribe each Rapid Fire Wednesday and post it to a weekly newsletter that you can subscribe to. The link to subscribe will be in the video description. So until next week, have a great rest of your week. Good to see you again, Mickey.
Good to see you, Kim.